Thank you, Kelly, and good afternoon, everyone. It's great to be with you again. This is the second webinar in our series. The first webinar, we talked about when bankruptcy is appropriate and when it's not, and how to screen clients for that purpose. This session will focus exclusively on the various documents that need to be prepared and filed in the bankruptcy process. And all of this is leading up to the all-day in-person training that will be performed at two separate locations with substantively the same materials or the same information being covered in that all-day training. The first option is Harrisburg, which will be conducted by my colleagues Mike Froelich and Jonathan Scrow. The second option is in Pittsburgh, and that will be conducted by Catherine Martin and Eileen Yakman. So when I refer to the in-person session, that's what I'm just talking about. I do strongly encourage all of you to please go to that chat box and download the documents that have been placed there by Kelly. We will be relying heavily on those throughout the day or throughout this training. The one document that I included is the client checklist. This was actually also provided in the first webinar. So this is a tool that we use to help our clients gather the necessary documents so that we can prepare the bankruptcy filings that we're going to talk about today. So obviously, for instance, like the clarified information, you'd want to put that for the credit counseling or organization that you would use in your area, but it can be a generally useful tool. One thing I want to emphasize about this is you'll notice the tax returns mentions the last 4 years, but you'll see that there are actually 5 years currently listed. That's because we are in the area right now where tax returns can be filed for 2018. Every year when you're in that cycle, so if you're preparing a bankruptcy between January 1st and April 16th or 17th, which is tax season, you need to make sure that you're gathering the taxes that they filed for the 5 years in advance because of the way that the counting is done. It triggers that you have to collect all 5 of those years. And actually, officially, you don't need to collect all of those documents. You just need to know that your client has filed all of the necessary tax filings for federal, state, and local tax obligations that may exist. If they were legally required to file tax filings in a particular year in that four-year look back, you need to make sure that they've done that, and they have to certify that as part of the bankruptcy process. As a general matter, I like to make my clients show me that they've done it because many times our clients don't know what they have and have not done. And that can be a fatal defect in a bankruptcy case if it turns out that tax filings were not completed as required. You will absolutely need to submit the most recent filing of the federal taxes to the trustee. So even if you're not collecting all of the years, you must absolutely collect the most recently filed tax filing for the federal. That must be submitted to the trustee. Okay, so moving along. So when we're creating all of these documents, and you'll see if you look at the big packet, the PDF that's called Bankruptcy Webinar 2 Bankruptcy Filings, it is a very large packet. I think it's 50 pages for the version that the sample version I've created. And all of your clients are going to have something that looks like this. These documents are all the mandatory documents, and there's an enormous amount of information that is asked for, and they seem to have, at different places, overlapping questions that are capturing portions of the same information, but they're not identical. And it can really feel like a head scratcher. It's like, geez, why do we need all of this? I have most of my clients ask me that at one point as we're going through this. So it's important to remember kind of these core concepts about bankruptcy. The purpose of bankruptcy is to bring the entirety of a person's financial life into the oversight of the bankruptcy process and identify all of the assets and all of the creditors, and then appropriately distribute or reorganize the estate of the debtor so that the creditors can be addressed in accordance with bankruptcy law. So the goal of all of these filings that we have to do is to create that full, complete financial picture of your client's life, of the debtor's life. And it's not optional to provide this information. So if you have a client who is resistant to disclosing things, you have a situation that maybe bankruptcy is not appropriate for a person, or, you know, if they refuse to leave bankruptcy and you're in one, you might have an ethical problem if they're refusing to disclose information. So it's important that you go through the due diligence of reviewing those documents with your client thoroughly, and also doing a certain level of due diligence outside of the basic client interview. So checking, so some of the various research portals, Westlaw, Lexis, you can actually get a financial report that includes like credit reports, judgment lien searches, and, you know, other lien indices, properties and public records, court cases and public records. If you can get those resources, that's great. You can also kind of do that ad hoc on your own, and by gathering and checking all those different sources. I know the cost can be an issue that comes up for that part. So to perform a bankruptcy, it is 9 easy steps. That's all bankruptcy is, which of course there are lots of little steps embedded in this. So what's important is that before your client files the bankruptcy, they must complete a pre-bankruptcy counseling session, credit counseling session, with an approved provider. All right, so if you've never done this before, you can go to the United States Trustees website. They have a master list of every approved credit counseling agency, but they are approved specific to each district where a bankruptcy court lays. So the Eastern District of Pennsylvania has a different list of approved counselors than the Western District of Pennsylvania or the Middle District. So if you happen to be in an area where you might be practicing in 2 different jurisdictions, you want to make sure that the counselors that you're using are acceptable for the court in which you are filing the bankruptcy. What I always tell my clients is that certificate of credit counseling, that is their ticket into bankruptcy. There are some very small exceptions where you can petition for a waiver of that. I don't do the petition waiver. I just get every client to do it. It's so much easier to, and you know, it takes almost nothing to go through the process. It's like half an hour on the phone or on the computer. It's just a matter of getting it done, and that's so much easier than going through the petition cycle and the hearing and risking that it'll get denied. So whenever you are able, you know, make your client get that counseling session certificate. It's important to note that you can't just say, I didn't have time. You have to demonstrate that the person attempted to get an appointment with 2 separate providers, and neither of them were able to give them an appointment prior to filing the bankruptcy. Again, that can get really complicated to properly document that. But the other thing is, if you look at these lists, you can get providers that are able to do these things 24/7 online, super easy to complete the process. So, you know, if you just ask the right place, you're going to get somebody who will do the credit counseling for your client, and you're going to get that certificate. It's easier than trying to get around that requirement. All right, so preparing the forms. Okay, so this is where you should look at the filing checklist. So the filing checklist is one of the documents. Where is it? Here we go. Okay, and again, this is a document that we've prepared in-house, and we add to it as our court adds other fund requirements. You can modify it for how it makes sense for your office, but what I do with this document is I print it out and I staple it to the front of the file for the bankruptcy, and it's my master checklist of what we've done and what we still need to do. And it's a great way to communicate when I'm working and partnering either with another attorney or with a paralegal or another support staff person, because we can easily look at it and see what have we done, who's working on what, and it helps us keep track and make sure that we're hitting all of the requirements. There are some really key points in this. You'll notice that there are a series of lines, and those lines are intended to capture the items that are crucial for each stage of your bankruptcy. The absolute minimum to file a bankruptcy is you need a petition, a bankruptcy petition. Then ideally, you'll have your certificate of credit counseling. If you don't have your certificate of credit counseling, then you need that petition to waive the certificate of credit counseling. And then you need the filing fee or some kind of a request to not have to pay that filing fee. And that's what those items are underneath. Informa Pauperis is only available for Chapter 7s. Hopefully, all of you are thinking in the Chapter 13 world right now because we're thinking about how do we save homes. We save homes through Chapter 13s. You cannot get Informa Pauperis status for Chapter 13. That means your client will be paying the filing fee. So there is a form that's a request for payment of filing fee in installments, which means that you don't need a penny, or sorry, your client doesn't need a penny on the day you're filing. They can submit their installments over the course of 4 months after the bankruptcy has been filed. And then if you have a repeat filing, if your client has filed a previous bankruptcy within the past year, and that's a 365-day year, if your client has done a previous bankruptcy within that year, there are limitations on the automatic stay. And so if this would be their second bankruptcy within a 12-month period, then they will get the stay automatically, but it is only good for 30 days. If you have a case where you're experiencing that issue, at the point that you file the petition, you must also file the motion to extend the automatic stay. And typically that's filed as an emergency motion so that you will have a decision before the 30 days expires so that you have no lapse in the automatic stay. If this is a third or subsequent bankruptcy within the same 12-month period, there is no automatic stay. And so in those instances, if you have a case like that, you would have to file a motion to impose the stay. And again, you'd probably want that as an emergency motion. And then you have to wait for a judge to rule on it before you get a stay of collection activities. So that's part of why in the previous session, we emphasized determining whether or not your client has a previous bankruptcy or multiple bankruptcies, because it can have implications from the start of your filing. So those are the only documents. So really, for most people, you need three things: petition, certificate of credit counseling, and filing fee or installment application. That's all you need to file a bankruptcy. You got to do a lot more after that. But if you have those three things, you can initiate a bankruptcy and get an automatic stay for someone. Now, the next set of documents are not mandatory, but it's just a good idea to get those filed at the same time. For instance, the statement of Social Security number, it's super duper easy, so you might as well just get that filed. There's a statement of attorney compensation. That's really easy. The numbers are zeros. And so those two, it's just easy enough to file them. You don't have to worry about them after that. Then you have the matrix. And the matrix is the complete list of all the creditors and other parties that need to be noticed in the bankruptcy. That is required within 7 days of filing the bankruptcy. So typically, if you can get it in when you first file, that's great. A lot of times you're still trying to gather all that information at the point of filing. But remember, that's a 7-day deadline. Everything else below is at least a 14-day deadline, but that matrix is 7 days. And if you miss that deadline, they can dismiss the entire bankruptcy with no other hearing first. So you want to be very careful about making sure you hit these deadlines. Again, that's why as much as possible, I try to file that at the initiation of the case. There's also this thing called the CMI, which is the Statement of Current Monthly Income. And for that, that one tends to be harder to get together before the 14-day deadline. It's a complicated math formula to create. But the courts don't send out the notices until you file to the creditors, until you've filed your CMI, at least in my district, that's how they do it. So by filing the CMI with the petition, it means that the notices get out to my client's creditors faster. So when I'm able to get that done with the petition, I try to do that. But you get 14 days to do your CMI. And when I say 14 days, all of this relates back to the date of the petition filing. Thank you, Dave. I see that we have a question about the costs of the credit counseling, the pre-bankruptcy credit counseling. The counselors are allowed to charge up to $50, and that's $50 if you have a married couple who will be filing jointly. They can attend one bankruptcy credit counseling class for that same $50 fee. However, every one of your clients should get that fee waived, because all you have to do is send a letter to the credit counseling provider that says, hi, my client is low income. I am providing free services for the bankruptcy. Please waive the fee. Under law, for the bankruptcy law, the credit counselor has to have an option to do a fee waiver for low income people. And since I'm talking to no one but legal services, every one of our clients should be in that category. Sometimes when you're doing like a quick, fast process and you're trying to get everything done like within 2 hours for an emergency, it can be harder to get that waiver completed, and a client may elect to just pay the fee. But if you have any opportunity to plan in advance, it's super easy. We have a form letter that we use. It's literally 2 sentences long, and we just process it. Part of who I send my clients to for credit counseling is determined by how easily the company is able to process those requests. So I have tried different places, and when I find a place that's difficult to get those fee waivers, I cross them off my list. And I've found through trial and error, I've found agencies that are very easily to, get that processed through and let my client complete the process. And I try to connect my clients with those agencies as much as possible. Thank you for that question. I appreciate that, Dave. Okay, so let's go on with the form. So we talked about the petition. Now's a good time to open up that big PDF that's all the different bankruptcy filings, and you can see what some of these documents look like. Let me get that for you. Okay. I mentioned in the last webinar, use a filing fee prep software. Best case, who else is out there? I used another one at my last job, and I'm forgetting it right now. There are lots of different companies that have created these programs to help prepare the documents. You shouldn't be doing this stuff by hand on a blank form. Let the computer do this work for you. It is absolutely worth the investment. So this is what a voluntary petition looks like, and it will explain which bankruptcy the person is filing, the name of the debtor. So in this case, I've used my own name for this purpose. You'll notice that the Social Security number is only showing the last 4 digits. That is why there is a separate document called the Statement of Social Security Number. That document, let me go to that one. Oh, that's going to be at the end, sorry. So the Statement of Social Security Number is the only place that the entire Social Security number is shown, and that document is docketed separately from the rest of the petition and the rest of the filings, and it is docketed as a sealed document. So it's available to court personnel, to the judge, to the trustee, but nobody else can see your client's full Social Security number. It's absolutely your professional responsibility to preserve your client's financial secrecy for to prevent identity theft. So you should never submit anything on the public record that includes the full Social Security number. Again, the computer program automatically puts in the X's for those other digits, and the last 4 of the social are the only thing that will be on any of the forms that you'll see in the public record. Okay, so the petition summarizes very quickly kind of a quick capture of what it's going to look like. It's important here, they have a question about, has the person lived in the same address for the last 180 days or within the district that you're filing? If you have a client who's recently moved to Pennsylvania or recently moved to their current location, they're not allowed to file a bankruptcy until they have resided in that district for 180 days, and that's 6 months. So it's important that if you have a recent relocation, either you have to wait to file the bankruptcy, or far more complicated, if they want to file within that 6-month window, they have to go back to their previous venue. So if they were an out-of-state relocation, they're subject to the venue of the previous state and the previous court over there. So as much as possible, try and wait for that 6 months to complete before you file. If your client has ever been operating a business, it's important that you capture that. Let's see what kind of bankruptcy they want. You'll see here they ask about the filing fee, and we're going to see that installment form in a moment. Sorry, this is a bit small. Maybe that's easier. Let's see. Again, you can see a lot of these questions are the same screening questions that we flagged in the previous training. And these have to do with whether or not the client's allowed to be in bankruptcy, whether or not they're in the right place, and so forth. Let's see, bankruptcy with a spouse, tenants. So this is about home ownership, and so we're not going to talk about tenants, but if you ever do a Chapter 7, there are special rules for tenants that are facing potential eviction. You'll need to understand those if you're practicing in that area. Okay. And now this is the question about the credit counseling. And their choices are, I've done the counseling within 6 months of the bankruptcy. So if they did it 7 months ago, it's stale. They have to do it again to have that ticket into the bankruptcy, that certificate of credit counseling. And remember, it must be a pre-bankruptcy credit counseling. It cannot be they couldn't go to a counselor and just have a standard counseling session. It has to be specifically labeled as bankruptcy. And I'm going to go along fast because I see I'm starting to get a little behind. These are summaries of what their assets will look like. You want to try and get these right. If it turns out later that the numbers are different than what you estimated here, you actually have to amend this form to reflect the correct information. Okay, so other thing, just a quick note, you'll see here, this is where the person is supposed to sign. The computer programs will do an automatic e-signature that is acceptable for the court. You can e-file documents with this e-signature as it is. However, with all e-signatures in the federal system, that is not good enough for your file. It's good enough for what you submit to the court, but the court always has the right to come back and ask for the wet ink signature on that document. And so you have to have your client put pen to paper and do a wet ink signature. We do it right here in the blank space next to the e-signature, and you have to retain that in your file. And in these bankruptcy forms, you'll see there are multiple places that you have to have a signature. You need to go through these forms with your client and do those wet ink signatures, because when you get to the meeting of creditors, you have to produce those wet ink signatures at the meeting of creditors. So make sure that you're doing this step with good practices in the beginning before you submit these documents. You don't want to be in a situation where you're missing signatures. That's a big problem if you have that. Okay. Oh, and this second one here is actually the attorney signature. They're less worried about the wet ink on the attorney signatures because your act of logging into your e-file account constitutes a signature. Okay, this is the application to pay the filing fees and installments that we talked about. You can do it automatically with 4 installments. You can request an extension to 6 if you really need it. That's a separate motion. You can break it down any way you want there. This is just the proposal that you're making to the court, and they default to this because that math gets you to the result that you want. But let's say you want to do 25 and 25, and then you do 2 that are like each to 150 or whatever. As long as you get to that final filing fee number in the 4-month period, they're happy. Okay.
Jennifer?
Yes.
Excuse me, I'm going to launch the first of the CLE credit polls. Attorneys out there, if you can please respond so that you are halfway there to earning credit for this session. Thank you, Jennifer.
Okay, moving along. All right, so now we've covered most of this top part of the page. Then we get into the schedules, okay? And it looks short on this page, but that's the bulk of your packet we're dealing with. So the first is the summary of assets and liabilities and the certain statistical info. Don't try and figure that out. Let the computer fill that all in for you. Once you fill in schedules A through J, all of this gets automatically populated as long as you're using one of these preparation programs. Okay, now let's go into the meat of what we're going to talk about today, which is the schedule. So you have Schedule AB. It used to be 2 separate documents. Now it's 1. The purpose of Schedule AB is to capture all of the assets owned by the debtor. Let me just make sure I'm covering everything on my PowerPoint. I know I'm jumping around a little bit. Okay, so you have to report all of the assets of your client. You also need to give each asset a realistic fair market valuation based on its current condition in a secondhand market, okay? They have a special set of rules for cars. So the house has to be full market value. The car, you have to use a Kelley Blue Book dealership resale, not trade-in, not third-party private. If the dealership is selling your vehicle, what would they get for it? That is statutorily required. There's no debating that fact. And you can just go to kbb.com and punch in the information and get the valuation right there. If your client owns an item that is worth $600 or more, it has to be individually itemized. 600 might not be the exact number. That changes each year. It's rare that our clients have a lot of that, other than like, maybe a computer or, a motorcycle or something like that, or a car or a house. But you want to make sure that you're asking those questions, and that if you have anything that you're identifying them individually listed on the forms. You can lump together items that are of lesser value, and they can be, so for instance, personal wardrobe, and you just say personal wardrobe, and you can put, $2,000 as an estimate for how much the entirety of a person's clothing wardrobe is. Similarly, for, furniture, household furniture, or, ordinary or appliances, you get the gist. So the really important thing to remember here is assets are not just the things, but all of those legal rights that your client may have. They are assets, and they are required to be reported as well. And that can be a really tricky thing. It can be harder sometimes for people who aren't used to thinking about assets in that way, and that could be our clients or our staff. So we want to make sure people are understanding all of the things we're looking for. So various things that we might not think about that can be assets. So here in this sample, I've included a cell phone. Okay, it's rare that our clients have expensive cell phones, but if you have a client who's walking around with a brand new iPhone, that's gonna, high quality new phones are worth $1,000 now. So they could very well be required to be listed individually and whether or not they owe money on it. This is not net value. This is full value. And then they determine the net value at a later point in the next schedule. So even if they still owe, $600 of payments before this cell phone is theirs completely, that is still an asset that's worth over $600. Collectibles, sometimes our clients will have collections, so it's important to identify those. Firearms, that's another one. Sometimes firearms are actually worth a lot of money. I'm not a gun person, so I didn't realize that till I had a client who schooled me on it. They can have a lot of money in firearms if they're a collector. Clothing, jewelry. Jewelry needs to be listed separately from clothing. And people have a tendency to say, no, I don't have any jewelry. And you're sitting there and they're wearing a gold chain and 2 rings. And you're like, what about the stuff you're wearing? They don't tend to think of that as anything worth anything. But even if it's only worth $25, got to be listed, personal jewelry or costume jewelry, that if they have a large costume jewelry collection, it could be worth 50 or 100 bucks in total. Just list it. My goal here is disclose, disclose, disclose. Sometimes clients are afraid that by putting something on here, it's a problem. The problem is when you don't put it on these forms, okay? You want to disclose the existence of the asset here and exempt the asset on Schedule C so your client gets to keep everything. So disclose, disclose, disclose. I see another question. We have a debtor who's a homeowner who rents out a home. How do we evaluate the fair market value of a lease? That's a good question. So I think you'd probably use kind of like what real estate agents use, which is the right to collect the remainder under the lease. Because when somebody signs a lease, if it's a term lease of like a year, there's actually a contractual right by the landlord to collect the entirety of that year's lease. Even if they have to evict the person partway through the year, they can still demand a judgment for the entirety of the obligation under that term. So I would say that would be the starting point. If you have a term lease, you add up the amount that's not yet collected under that contract. That's the value of the contract for simple math. If it's a month to month, then I think arguably the contract right is only a 1-month contract right, and then after that it's just kind of money that you could get, but you don't have a legal right to. It's not necessarily a schedulable asset beyond the single month that they're entitled to collect. But this also brings up a great point. If you have money that's owed to your client, so let's say they have that tenant and the tenant's behind by 2 months in their rent, that right to collect the past due amount, that's an asset as well. All right, and not just in a tenancy situation, but in any situation, if somebody owes your client money, that's an asset, put it on here. You'll see here deposits of money. So sometimes our clients have to put security deposits with utilities companies. That goes in line 17. Cash, okay? Cash is not just the stuff in the bank. It's money in your wallet, in your house, in a safe deposit box, or in their hand, okay? And I also tell my clients, what about between the couch cushions? All right, and so, you know, everybody's got a little bit of cash somewhere, you know, even if they're scraping the bottom of the barrel, there's still a couple of bucks somewhere. So it might just be $5 or $20, or maybe they just got their Social Security check and they're carrying around $600 in their pocket. Identify that. And the point of reference, and they mention it here, everything on this schedule is the day you file the petition. So that is your point of reference. So even if you're preparing the schedules later to file them within the 14 days after the petition is filed, all of the answers should relate back to the day the petition was filed. Okay. Don't forget to ask your clients all these crazy little questions about investments. You'd be surprised what's out there. One time when I was preparing to bankruptcy, I discovered my client was a beneficiary of a trust from her father's estate. So we put the brakes on the bankruptcy and dealt with that part instead. Patents and copyrights. If they had a company and they have a client list, they want that on here. Family support. So if your client is owed alimony or support, that would go in here. Child support, that's an interesting one. Child support belongs to the child. So I'm not sure how that should get scheduled. I haven't had that. Other amount somebody owes you. If they have claims against third parties, whether or not they have filed a lawsuit, this is one where we run into this all the time. Clients have been in a car accident, or there's been some other problem, and they have or maybe they have a slip and fall or a medical malpractice issue, and they have a lawsuit filed, or they're talking to a lawyer, or maybe they aren't intending to pursue the claim at all. If they have a legal right to pursue damages, that is an asset. It may not pan out, they might not win, but it's still an asset and it needs to be scheduled, it needs to be valued, and it needs to either be exempted or it becomes an asset that the trustee could take over. So it's really important that you don't miss those things. I've had clients who haven't mentioned to me the personal injury lawsuit that they filed, and we discover it when we're searching the court dockets, and we have to put the brakes on everything and sort out what we do about that before we move forward. Okay, so there's somewhere in here is inheritances. A person who thinks they're going to inherit does not have an asset, it's an expectation. But once somebody passes away, if your client is an heir, then it becomes even if they have not received the inheritance yet, once the death has happened and they have a right to inherit, that needs to be scheduled as well. All right, I think I've covered most of this. One of the things I've struggled with here is we have more and more clients who are they're not using bank accounts, but they're using prepaid credit cards as a bank account substitute. And that is something that I have struggled where to place that on here. So I have tried to use number 35 because there's no place else that fits well because it's not a bank account. I had a trustee who didn't like it there, but they never told me where else they wanted it. And so, but just remember, even things like that, because if they've got $300 sitting on a prepaid card, that's your client's money. That's an asset. All right. Pardon me. Okay, let me just go back to this and make sure I've covered all of this. Oh, sorry. Okay. So the next schedule is arguably one of the most important schedules that we prepare. Schedule C. This is where you tell the court why your client gets to keep their stuff. If you get Schedule C wrong, or if you forget to exempt something, the potential result is that your client has to give up that thing they forgot to exempt. So it's really important that you exempt. Your goal is to exempt absolutely every dollar. You know, if you run out of exemptions, then you have to figure out how you deal with that problem, but you want to try and exempt everything possible. Okay, so for most of us, we're going to use the state rules, which are under the Bankruptcy Code, which is 11 USC 522B2. You can elect, I'm sorry, I said for most of us, we're not going to use the state rules. You can choose to use them, but Pennsylvania has really, really awful state rules. So instead, we are going to use the federal rules, which are the 522B3 and 522D. And you basically just open up the rules book and go down the list, and you can see all the great exemptions and what you get to keep. They have annual adjustments for inflation, so you need to make sure you're working off of a good, fresh copy of the rules or the law. You also, if you are using a computer prep for your software, you want to make sure that software gets updated annually with those adjustments. Otherwise, you could be working on stale information. You get to double the exemptions for this when you have spouses. So I'm not sure if this is the exact correct number. I'm sorry, I'm not sure I updated this for 19. So you get equity in a residence is under D1, so that's your house. And remember, it's the equity, and that's where you are looking at the net value of the house after taking out any secured debts against that asset. There's a special exemption for a car. Then you get about $12,000 for household items. You get a special line item for jewelry. Then you get this great thing called the wild card, okay? And this is where, and you can basically use this for anything, all right? So let's say the car is worth $5,000, not $3,000, and you're like, geez, how do I get to keep my client's car? So you exempt the first $3,775 of the car value using the car line item, and then you borrow from your wild card to get to the full $5,000 that you need. Okay, so this is like think about all of these exemptions as like monopoly money, and you can like add them together as long as they're properly applied to the item that you're trying to exempt. You can add them together to get to the totals that you need. So you get the standard. Everyone gets the 1250 wild card, and then there's this extra piece of the wild card, which is if a person doesn't have that much equity in their house and they don't use all of the house exemption, they can carry some of that over and use it for anything else that they want. And that's what that $11,850 is. Okay. And then they've got a whole set of like specific line items. So if you have a client that has special health aids like wheelchairs or breathing machines, all that, like that medical stuff can get expensive. They get a special line item, which I don't think has any dollar value limit. Retirement accounts, that'll be your 403Bs, 401Ks, Roth IRA, or IRAs, traditional IRAs and Roths. All of those are exempted, no dollar limit. Right to receive government benefits. If you have a client that's getting Social Security or SSD, or if you have a client who has a pending SSD claim, that is an asset. So it has to be scheduled on Schedule AB, and then you go to the specific line item exemption and exempt the entire value of that asset. Right to receive alimony and child support is also an unlimited exemption. Some life insurance, it has really special rules. Some judgments related to personal injury and death. And again, that would be judgments that your client is collecting, not that they owe. Tools of the trade. So if you have somebody who's a carpenter or somebody, or beauticians, you'd be surprised how much those cosmetics, like if they have a nail salon, they have a lot of money in all of those different beauty products. All of that's a tool of the trade and can be exempted as well.
Jennifer,
okay.
We have two questions on wild card.
Yes.
The first one is, can you use the wild card multiple times up to the financial ceiling?
Okay, so the wild card is $1,250. You can split up that $1,250 any way you want, but you only get one $1,250. Does that answer that question?
I think so. I think you answered the next one as well. Can you split up the wild card, for example, some for jewelry, some for the car?
Yeah. So I'm sorry, what was the first one then, the first question?
Can you use the wild card multiple times up to the financial ceiling?
Yes. Yeah, so you can split up the wild card, but you only get one wild card, the 1250, and then if you're carrying over some of the home equity into a second wild card, you can only use, when you add up all the different ways you've used it, you cannot exceed that max amount that they've allowed for. Okay, so let's take a peek at what Schedule C looks like, and then we'll move along because we got a lot to do. So here you can see, here's the house, the full market value of the house. Then we have the equity in the house, all right? And then we have the exemption that I'm using to keep the house, because the rest of the house is already taken by the liens, the mortgage liens on the property. All right. So then we have Schedule D, E, and F. Oh, sorry, Schedule D and Schedule EF. Those are your creditors, okay? Schedule D is any secured creditor. So primarily you're going to have mortgage, car loan, any property taxes, other municipal liens that might be attached to the house. If you have a client who's gone and borrowed against their whole life insurance policy, that's a secured creditor. Don't forget about that. All right. Schedule EF are the unsecured creditors. So their rights have not attached to a specific asset. If you have so a judgment lien, I don't think it would be listed. It might be listed in both. I have to think about that and where the judgments go. So for EF, it's meant to capture priority creditors and non-priority. And when you're in the list, you'll see in the computer, it has a whole list of who's priority. And that's basically like, do you owe taxes? Do you owe child support? Do you owe alimony? There's a whole list of people who get paid before anybody else, and those are the priority creditors. And then everybody else who's non-priority, they all get treated the same. And this is where you want, again, disclose, disclose, disclose. If you are not sure, if your client says, I don't owe that money, you still put it on here, and then you put, it's disputed, all right? There's a place here specifically to indicate, I don't think I owe this, but I still want them to be treated, but they say they owe it, so I want them to be treated as a creditor for purposes of my bankruptcy. You always have the right to still fight about whether or not that debt is owed at a later point in the bankruptcy. So let's see, let me go back to the PowerPoint and make sure we're covering all of this. So when you're preparing Schedule D, you want to make sure that you're cross-referencing it with the assets in AB. The computer programs that prepare these forms give you a place where you can do that linking right in it, usually at both locations. So when you're putting in the asset, you can also hit a tab and put in the debt that goes with it, and it will automatically place that on the other schedule, or vice versa. Make sure you learn how to use that part of your computer program so that everything is properly cross-referenced, and that way your forms are filled out correctly. There are also places for additional notices. So, for instance, if your client has a mortgage, that means they're going to have the mortgage holder, the servicer, the foreclosure company, who's the foreclosure firm, who is the law firm handling that, and then there might be some other kind of entity like a debt collector involved. All of those extra people should be included as an additional entity to be noticed. Again, these computer programs usually will have a place where you can add that right in, and then all of those names will be put on the matrix, and every one of those entities will get a separate notice of the existence of the bankruptcy. All right. Okay, so the other big thing when you're preparing this schedule, the list of creditors, D, E, and F, if you make a mistake, if you leave something off and you remember it later, your client has to pay a fee to file the amended schedule. It's, I think, $36 or $39. So it's really important that you're very thorough And I also tell that directly to my client. I'm like, hey, are you sure we're not missing anything here? Because if we are missing something, you're going to have to give me the money to pay for that amendment. And that's not for me to prepare it. The court's going to want that fee. And I will tell you, I've had very angry clients who come back later and they're upset about why I'm asking for that extra money. And I'm like, we talked about this. So you want to try and be as thorough as possible. And again, when we talked about the matrix, and the matrix is due 7 days after the filing, if you have to amend that matrix or add a creditor to that matrix, there's also a fee there. So putting the effort into making sure you have captured all creditors and all parties to be noticed and that they've been properly put on these schedules will save you a lot of effort and your client money. All right. So here's some different examples. So family debt, okay. People often think, I don't want my parents involved in this. I don't want my sister involved. They don't want their name included in this. Creditors, it does not harm a creditor to be named in a bankruptcy. It just means that they're going to get the notices. And your client has no choice in this matter. The bankruptcy law requires that they disclose all of their debts. So if they have borrowed money from a friend or a family member that needs to be scheduled, you need to instruct your client that they cannot make any further payments to that friend or family member. That would be considered a preferential payment, and it's not permitted in the bankruptcy law. And this person is actually, because they're not an arm's length creditor, they actually get an even lower priority in the bankruptcy than any other creditor. Don't forget utility delinquencies, even if your client is on cap and they're not required to make payments. If there's an old balance, you want to make sure it's disclosed in here. Don't forget, we double schedule the debts. So let's say the client owes, they originally owed Discover, but now it's been sold off to Portfolio Recovery. Make sure to schedule both creditors. Over disclosing is absolutely the best policy. This is a student loan. Student loans are considered a non-priority debt, but they are also non-dischargeable. There's a whole, we don't have time to talk about it. If you have a client with a student loan, there's a whole separate set of issues you have to address because they will leave bankruptcy and still have that student loan to deal with. Okay. So Schedule G is your executory contracts. And this would be, so I think, Dave, when you were asking about a lease, you were thinking of it as an asset, which it is, and it's in that context where your client is the landlord. So you should absolutely schedule that as an asset, but also as an executory contract. So you should also schedule it here. If your client is a tenant, equally that would get scheduled here. Some of the ways that the transactions our clients will have here, if they have a contract on their cell phone plan, that's an executory contract. If they have a rental agreement on furniture or other items like that, that is something that goes in Schedule G. And again, our clients don't know what an executory contract is. They have no idea about these things. It's our duty to bridge that gap in knowledge and understanding, to ask those questions and make sure that we are capturing all of this information that is required. Okay, cell phones. Cable, if they have like a 2-year commitment on their cable contract. Vacation clubs, that's kind of the new timeshare, but it's not a timeshare, it's just a club. Those are executory contracts. Home security systems often are written like cell phones and cable company contracts where you have a commitment period in the contract. Then you have Schedule H, CoDebtors. Again, this is an area where people get frustrated about because they're now listing their family and their friends. So if they co-signed on the car, they co-signed on the mortgage, they co-signed on the student loan, all of that that's a co-debtor. This does not harm the co-debtor. This is about the person receiving notice, and it's also about them getting the protections of collections. They can't go after the co-debtor when the debt is in the bankruptcy. So it's important that they get listed here. Okay, Schedule I, and then right after it is Schedule J. These two schedules work in tandem. I is the income of the person from all the various sources that they have. J is how they're spending that money, but not how they have spent it in the past. J is about how they intend to spend their money while they are in the bankruptcy. And so this is kind of aspirational and estimated, all right? And so we spend a lot of time in preparing the bankruptcy with the goal of getting a budget in J that's going to make for a successful Chapter 13 bankruptcy. And here's the magic that you have to do. So this particular example, the person does not have a balanced budget. This is not something you should ever allow to get filed. This would be an instant motion for dismissal for lack of feasibility, because there's no way this person is going to live under this plan, under this budget, and succeed in a bankruptcy because they have no money to put towards the plan. What you want is you want the client's monthly expenses to be less than their monthly income. You want to have extra money after their budget, and you want that extra money in this box right here to be exactly the amount they're going to make in plan payments to the trustee in the Chapter 13. How do we get to exactly? Well, it's a results-oriented process. So you keep looking down there and you see, oh, if I change the food and I reduce my client's food expenditure by $25, does that put me where I need to be? Oh, wait, now I've written the budget and there's too much money extra at the end of the month. Maybe you need to up the allocations your clients will spend on things like clothing or home repairs or food. So there are some places that are kind of mushy where you can build in more. And again, just the bankruptcy process does not expect people to live in abject poverty. That is not the purpose of bankruptcy. The purpose of bankruptcy is to allow people the relief from their creditors. And it's reasonable for them to be able to live a standard lifestyle, not a luxurious lifestyle, but not bare bones. All of our clients are living a bare bones lifestyle. So we can allocate money almost anywhere and they're not going to challenge it because they're not trying to maintain 2 sports cars and a $500,000 house. Those are the folks who wind up in trouble with Schedules I and J. We are not those people. The places you want to watch out for, if you have a client who's paying for private school, that can be a problem sometimes. If you have a client who's a smoker, who's spending a lot of money on smoking, that can be a problem. And religious donations, okay? So line item 14, if a person's religion requires a tithing obligation, they are allowed to schedule that on their schedule. And nobody will challenge that unless they exceed 10% of their monthly income. So if you have a client, and in this example, we have a problem because the client's income is only $3,000 a month, so they're giving 15% of their monthly income to tithing. The trustee will challenge that and will want the rest of that money to be allocated to the plan payments. All right. And I know I'm getting
I'm going to launch
certainly.
the second and final poll for CLE credits for attorneys. Please respond to this. And also we have 2 questions. Did you want to take them now?
Yes.
Okay, the first one. Would a leased cell phone valued at $1,000 be listed as an asset, then listed with the amount still owed, and then listed again as an executory K?
Okay. Wait, I'm sorry. What's the question again?
Would a leased cell phone valued at $1,000 be listed as an asset, then listed with the amount still owed, and then listed again as an
executory contract? Okay. All right. So this is a good question because the question shows that there's a misunderstanding about what an asset is. Okay. The cell phone itself is an asset. So the cell phone, if it's more $600 or more, the cell phone absolutely needs to be scheduled independently and listed and given its valuation. The contract that the client has is, in that instance, is not an asset because your client doesn't have the right to collect under the contract. It's a debt. Your client has an obligation to pay under that contract. So that contract in that example would never be listed as an asset. It would be listed under Schedule G for executory contracts. Okay. All right. Next question.
Some housing law folks possession of a Section 8 voucher as an asset and designate the, I guess that's
Amount.
The amount of the monthly subsidy as the value. I've never done it. It's never come up. Is this an issue/concern for anyone?
Not for this training because we're talking about homeowners. So Eileen, I thank you for raising that question. I'm sure it is important for practitioners who do those kinds of bankruptcies. I don't do bankruptcies unless it's to save houses. I've never had to deal with that particular question. But thank you for flagging it in case others out there encounter it. All right, moving along, because I know I've got not too much time left. So there are two big important forms we need to cover still. The Statement of Financial Affairs. This form is terrifying to people when they first start bankruptcy. And what I would say is just read the questions, okay? As a lawyer, you know how to read a long, complicated list of different things that go together and figure out whether the answer is yes or no. That's what the Statement of Financial Affairs is about. So just take your time. And the goal of the Statement of Financial Affairs is to capture historically how your client's financial life has looked. So the schedules are capturing the current picture of the client's assets and debts. The Statement of Financial Affairs is capturing historical behavior of the person's financial life. Just read the questions. So they'll ask questions like, in this year or the 2 previous calendar years. So if we're here in 2019, we want to make sure that we have 3 years that we're capturing, 17, 18, and 19. Okay, so that's the 2 previous calendar years plus the current year. Similarly, people get very confused with question 6. They're looking at the 90 days before the bankruptcy was filed. Did they pay a single creditor a total of $600? Every client you ask this question of gets it wrong. They're like, I haven't paid anybody $600. And then you're like, wait a minute, you have a $250 a month car payment. I thought you said you were current on the car payment. They're like, yeah, I am. I said, well, you've made 3 payments in the past 3 months, right? Yeah. Well, 250 times 3, that's $750. So that's a payment that needs to be reported in that answer. And again, it's our responsibility to bridge the gap in understanding between the client and these forms. It's our job to capture those things that we know are out there, to do our due diligence, and to make sure we're asking the client's questions they understand, not the legalese that's in these forms. Okay, lawsuits. Every one of us should have the foreclosure listed there. That's a lawsuit. So if we're saving a house, presumably there's a foreclosure. Make sure you list it in the lawsuits question. Gifts to charities. Again, this is one of those cumulatives where you add up all those little payments. So if the person's throwing $10 a week in the tithing basket, they're probably going to be hitting that $600 value. Losses. Okay, so question 15 asks about losses. Losses would include fire, theft, flood, and accident. Okay, so if your client says that they had a car accident, they totaled their vehicle, ding, even if they didn't total it, it's still a loss. They ask about payments that people made for help in advance of filing the bankruptcy. If they paid for that credit counseling, report it there. Question 19 has to do with self-settled trusts. If your client transferred land in that 10 years, that's that you want to be capturing it there. Question 23 asks if your client is holding any assets for anybody who isn't the debtor or isn't themselves. So I like to put in, if they have a spouse, or if they have a partner, or if they have adult children or roommates living in the house, all that stuff in the house that isn't the client's is stuff that should be listed in 23. Because technically, and this never happens, but technically, the trustee has a right to go into the house and inspect it to see if there's been a non-disclosure of assets of the debtor. So ideally, you want question 23 to be a pretty clear list of, or notice of, hey, there is stuff in the house that doesn't belong to the debtor because we listed it right here. And it doesn't have to be a line item. It's not reiterating Schedule AB. It's just meant to capture, what's out there. Okay. Okay. let me go back and show you the Statement of Financial Affairs, and then we'll do the CMI, and then I know I'm already out of time, but you really want me to do the CMI. So this thing that I'm scrolling through very fast is your Statement of Financial Affairs. Okay. This is the Statement of Social Security number that we talked about earlier. Okay, so this is the thing I'm calling the CMI, which stands for Current Monthly Income, which is neither current nor monthly nor income. This is a very hyper-technical document. The goal is to capture all income from the 6-month period before the month in which the bankruptcy was filed, which is like head spinning. I'd like to actually wait and file July 1st and makes my life easier for my clients if I'm right near that time. But you got to get every single pay stub together, and you have to actually add up the exact numbers. These are not estimates. They want the exact numbers, and the trustee will want you to hand over those documents to them to show how you came up with the numbers on this calculation. So they do have some exemptions here. So you don't report Social Security or SSI, and you don't report unemployment. And see, they have a place for that, unemployment. So you also don't report things that are not regular. So if they got a lump sum payment for something, that would not have to be included on this schedule. Then all of that gets added up and then averaged and then multiplied by 12 to come up with this fake number that's meant to reflect their annual income, which is just based on this really crazy formula that we've been talking about. They then take that number and they compare it to the area median income for the state that we live in. And lo and behold, our clients will always and forever fall below that number because we represent low income people. So for this form, if you ever do any kind of trainings with private practitioners, they spend a lot of energy talking about this form and how to do all this crazy stuff. We are not going to have to worry about this form. If you're not sure whether or not to include something in here, include it, and the vast majority of the time it's going to have no impact, because if your client's computed annual income on this form is less than the state median income for that same household size, then it means there's a presumption of no harm or no bad faith in the filing, and it means that your client gets to determine what they pay into the plan based on their budget on I&J. That's the whole reason for this form. We will pass this test every single time. If you wind up in some weird case where your client is failing this test, call me. I'll help you through it. Okay, so that's the CMI, and I think that's everything. I hope it's everything.
We have another question, Jennifer.
Certainly.
What about a person who bought a home from a land trust, has a lease, a mortgage, and no deed? How do we document for a 13? Is it the same as if this was conventional mortgage? Okay. Yes. And actually, I had a great email earlier this week from Paige Martineau at, I think it's Mid-Penn. She was just able to get a court to acknowledge that a lease purchase is the equivalent of a mortgage and that you can cure within a 13. That's already settled law, but it's great that we're still having the judges honor it. So yeah, if you have some kind of a crazy, weird land relationship and you want help on that, please feel free to reach out to me. I have all those different cases I can give you really easily. But for bankruptcy purposes, when your client is the buyer in an installment sales contract, you can schedule that like a mortgage. So I also was going to cover the meeting of creditors and other submissions. We're out of time. What I would say is every Chapter 13 trustee has their own document checklist that they want. I've given you some sample checklists of the various documents that you will need to provide at the meeting of creditors to support the filings that you've submitted in the bankruptcy filings. So get what your trustee wants and work off of that. They also have their own preferences for how you submit them. Many of them are moving over to these computerized submission systems. Learn that in advance. You probably have to create a login or account for that. Get set up on that and know how to do that so that you're able to give your trustee the documents they want.
Having everything organized and prepared is the easiest way to get through the meeting of creditors. It's called a meeting of creditors, but in truth, it's going to be you, your client, and the trustee. And the trustee is going to ask your client a bunch of questions like, did you look at these forms? Did you review them? Is everything complete and accurate? Did you leave anything off of here? Okay, so you want to make sure your client can say things like, yes, I have looked at these. So you want to make sure you actually show these papers to your client, then have them put pen to paper and sign it with the wet ink signature. Then you file everything. So that way you go smoothly through the meeting of creditors. The lovely words to remember in the meeting of creditors is, we can supplement, we can amend. If there is a problem, it's not a gotcha moment where they're going to throw the case out. It's an opportunity for you to have a conversation with the trustee about what they would like you to do to get things the way they want to see them on those forms, and to make sure that everybody understands the same information about the person's assets and debts, and that they're properly reflected in the forms. So you always, and at the end of the meeting of creditors, they're going to give you a to-do list of, we still want this document, I want you to amend this form, I want you to take care of this, and they'll give you a copy of that to take home, and that's your homework list. So, don't be afraid of the meeting of creditors, be prepared for it. There are some additional filings you have to do after the meeting of creditors in advance of confirmation, and that's when the plan is approved by the court. It's called confirmed by the court. And then again, when you get close to the discharge point, when at the end of the bankruptcy, there are additional forms. They're all reflected on this list, on this master list that I show you here. The one document we have not talked about is the plan, the Chapter 13 plan. They will cover that at the in-person training, either in Pittsburgh or Harrisburg. And I am done, and I will take further questions if people have them. But I want to let people free to leave if they need to.
There's two more questions up right
Certainly.
now. First one, last webinar you said that the renter's rebate from PA would be included in the income, but it's a lump sum payment, which you just said one does not include. Which is it?
Okay. Thank you for this question. Okay. So I made a very quick reference at the beginning of the webinar about the idea that there are various places and various questions that capture pieces of the same information. And that's precisely the kind of question that it is. So you would not report the rent rebate or any tax refund on the current monthly income, the CMI statement. It does not go there. However, there are two places that it would need to be reported, possibly three. So it would get reported in the statement of financial affairs. There's a question about all income that's been received in the past 2 years. And so if your clients received, a tax refund would not go there because that's income that's already been reported elsewhere. But if they have, but the rent rebate, that would be something that gets reported there because that's additional income. It also, when you have an outstanding tax refund, whether it is an IRS refund, a state refund, or a tax rebate or anything, if the client has filed the paperwork and is owed the money and has not yet received that money, you better make sure you schedule that on your AB and you make sure that you exempt that on your C. The trustees have been instructed all across the country to look for those things. They actively look and make sure that you've scheduled those refunds and that you've exempted them, because if you haven't, they are going to snatch those things. So absolutely be careful about that. If you have a client who's receiving EIC, you may even want to build that into the IJ budget so the trustee can't demand those monies each year to go to creditors. So thank you for asking that question.
Next one is, do we need to bring extra copies of the supporting documents and proof to give to the trustee, or is it enough that the trustee just reviews what's in the client file?
I presume anytime I show a document to the trustee, they're going to want to keep it. That may not always be the case, but I'm a big fan of having copies. So yeah, I think everyone has their own practices in this regard. But yeah, I always make sure that I have 2 or even 3 copies, because in theory, a creditor could appear particularly if you have like a crazy kind of individual who doesn't really understand bankruptcy. And I like to provide documents to every person in the room, because even though it seems like a very informal setting, it is technically a hearing on the record. It's kind of functionally a lot like a deposition, where your client is sworn in, and the trustee conducts the inquiry to your client, and then you have an opportunity to ask other questions or provide clarification. And it's all recorded. It's an informal hearing in that sense, although it feels very informal because it's often done in like an office somewhere.
Okay, the last one. When we were talking about items that do not belong to the debtor, does that include possessions of the minor children? What if the minor children have a savings account or a 521 plan?
Ah, fantastic question. Okay, so I will start with correcting some of the language that you used in this question. A minor child does not have a savings account. The parent has a custodial account identified for the benefit of the minor, which I hope then answers the second part of the question. Because it is the parent's name on the account, yes, it must be scheduled on Schedule B as a bank account, and then yes, you would identify it as a custodial account for the benefit of whomever. There may also be a place where it gets put on the Statement of Financial Affairs, definitely that question 23 or 25, but there might also be a trust question somewhere. So you just, you want to remember what's out there and make sure when you hit a question that you put everything that falls into that category. But definitely, yes. If your client's name is attached to a bank account, even if your client's money is not in that account, you must disclose.
Okay, and that's all the questions that we have gotten. I want to thank Jennifer so much for sharing her information, her knowledge and information with us today. Thank you everyone for joining us. We appreciate it and hope that you can join us on March 15th at either the Pittsburgh meeting or the Harrisburg meeting. Jennifer, did you want to say anything?
I just want to thank everybody for your time and your fantastic questions, and go get them. Have a great time in bankruptcy.
Thanks, everyone. Have a great day.